call Dr. Faruqi in reply.
Thank you, Mr. Deputy President. Mr. Deputy President, firstly, I'd like to thank all members for contributing to this historic debate today on the Abortion Law Reform Bill 2016, including my colleagues, David Shoebridge, Dawn Walker, and Jeremy Buckingham, and the Honourable Penny Sharp, the Honourable Trevor Khan, the Honourable Mark Pearson, the Honourable Ernest Wong, the Honourable Daniel Mookie, the Honourable John Graham, the Honourable Linda Volz, the Honourable Adam Searle, and the Honourable Robert Brown. I must say it is disappointing, though, that only one member from the government made their views known on this bill, which will be voted on today, and which is so important to so many in our state. I must also thank my staff, Matt, Maliha, Tamara, and all the volunteers who have spent countless hours, energy, and passion on the campaign to decriminalize abortion, and of course to my Greens colleagues for their ongoing support on this long and without question a difficult campaign. But what's the point of being in this privileged place, in this privileged position, if we don't stake our neck out on issues that our communities want us to address? I also want to especially thank the thousands of people across New South Wales, in cities, in regional towns, in town halls, in universities, and on the streets, who over the last 3 years have come out in support of this reform, who have campaigned hard, who have joined up with doctors and lawyers and women's groups to help draft this bill. And I acknowledge that some of you are here today. Thank you. You have all been vital in getting abortion reform on the legislative agenda. Dr. Philippa Ramsey, Julie Hamlin, Darrell Duncan, Dr. Caroline DaCosta, Professor Alexandra Barrett, Dr. Sue Jacobs, and Dr. Kirsten Black deserve a very special thanks. From the day we started thinking about this reform to the drafting of the bill and this campaign, your work towards this reform has been instrumental. The questions before this Parliament today are these. Do we want to remove criminal offences around abortion and leave it to be regulated the same way as any other medical procedure? Do we want to make sure that women are able to access a medical procedure in safety, with dignity, and in medical privacy? Do we want doctors who have an objection to abortion to refer patients on to another doctor who doesn't and who can give them a full gamut of options that they have? Mr. Deputy President, a vast majority of people in New South Wales and Australia have said, yes, we do, to all three questions. Again and again, polling has shown that a vast majority of Australians and people in New South Wales support a woman's right to choose and to decriminalise abortion. People in rural, regional, and metropolitan New South Wales, across party lines, age, and gender, overwhelmingly support the three changes proposed by the bill in front of all of us today. The bill that we are debating today is not a Faruqi bill, as has been claimed by some, or a Greens bill. We are just sponsors of this bill. I have brought this bill to this Parliament on behalf of the women of New South Wales, on behalf of medical practitioners, lawyers, and most importantly, the community that overwhelmingly supports the decriminalisation of abortion and the enactment of safe access zones outside clinics. Of course, it's personal as well. I am a woman. I have a 21-year-old daughter, and I want women now and into the future to have the unambiguous legal right to bodily autonomy and to make their own health choices without fear or the burden of criminality hanging over their heads. We know making a decision about an abortion is never taken lightly, and this is made even harder with the added barriers that are present at the moment. I recognize that there are some deeply held religious views in this chamber, but as lawmakers, we must remember that this is a secular parliament and a secular system of governance. Neither my religion nor yours nor anyone else's, should be allowed to deny women their rights and choices. I respect the rights of those whose faith or beliefs do not allow them to have or perform an abortion, but an individual's religious beliefs have no authority over the right of other individuals who make different choices. Abortion in New South Wales is procured through a legal loophole based on a district court ruling, which makes this procedure lawful if a doctor deems it is necessary to prevent a serious risk to the life or health of a woman. There is no doubt that this grey area of law creates a risk for doctors and women. Many public hospitals and doctors do not perform pregnancy terminations due to this legal limbo. Some have suggested that all is okay because prosecutions are rare, but it would be totally inaccurate to assume that there are no practical consequences for abortion sitting in the Crimes Act. Criminalizing abortion achieves nothing other than increasing the stigma surrounding the procedure, increasing delays in accessing services, and it makes access harder, more expensive, and privatized. If you have the money and you live in an urban center like Sydney, you probably won't have a lot of problems accessing a pregnancy termination. But what about women in Broken Hill or Walgett or Moree? You would be hard-pressed to find a specialist clinic if you don't live on the East Coast. Access to terminations in public hospitals is largely luck of the draw, dependent on that particular hospital's policy and even the opinion of the particular treating physician you're allocated. Would we accept this for any other health matter? I think not. I now wish to address some specific issues that have been raised in the debate. I have heard members' concerns about certain aspects of the bill. I have always been open, and still am, to discussing changes if they genuinely allay these concerns and don't further undermine women's rights to choose. However, I cannot accept the claim that the bill is badly crafted or deeply flawed. The bill before us today is the culmination of months of intense consultations with doctors, with lawyers, with health and legal professionals, with academics, with women's groups, and with the community. The exposure draft of this bill was released over a year ago, and I introduced the bill into New South Wales Parliament in August 2016. This is a bill that has been crafted carefully and meets modern medical practice and public expectations in the 21st century. Elements of this bill operate, and operate well, in jurisdictions like Tasmania, Victoria, and the ACT. The bill has been reviewed and endorsed by many organizations, including the Royal Australian and New Zealand College of Obstetricians and Gynecologists, the body responsible for training and examining obstetricians and gynecologists in New Zealand and Australia, the New South Wales Council for Civil Liberties, the New South Wales Nurses and Midwives Association, the Public Health Association, Women's Legal Services, New South Wales Teachers Federation, Australian Lawyers for Human Rights, the National Tertiary Education Union, Family Planning New South Wales, White Ribbon, Marie Stopes, and the list does go on. Over 300 medical practitioners have written an open letter to members of this Parliament in support of this bill. Over 100 law and criminology experts have written a separate open letter to MPs imploring them to support the bill. It's time for New South Wales politicians to listen to them. Yeah. Consultation has been raised by some members as an issue, and I find this quite extraordinary. I first gave notice of this bill 2 years ago and introduced it last year under the Baird government, contrary to the suggestion of the Honourable Catherine Cusack in the media that this is an effort to test the Premier on women's issues. This is not about testing anyone, but about making a much-needed and a much overdue change. Developing this bill has been considered consultative and a thorough process drafted with lawyers, with doctors, and it included a 3-month exposure draft process for public consultation. This has been far from a rushed process. How long are we meant to wait for politicians to catch up to the community? It's been more than 100 years already. At the beginning of the 3-month public exposure draft period in May 2016, I did reach out. I sent copies of the bill to the relevant ministers and shadow ministers and invited their feedback and asked for a meeting including the Honorable Paul Lynch, the Honorable Walt Secord, and the then MLC, the Honorable Sophie Kotsis, and the then Attorney General Gabrielle Upton, amongst many other ministers in the new Berejiklian cabinet. Many of you have received information and updates from me and had one-on-one meetings. My door has always been open. I don't think it is a fair assertion to say otherwise, and one that has been made in the media on the eve of the debate to score cheap political points. Some members have presented the unfounded argument that this bill allows abortions right up to birth, to the day the baby is born. These are also the myths that are being peddled by the anti-choice lobby. To suggest that women will carry a pregnancy to term and then terminate it is offensive and has no grounding in reality. There is no evidence that this ever happens. With modern medical practice and ethics, no doctor would do it. This bill is about taking abortion out of the Crimes Act and ensuring that women and their health practitioners are not treated as criminals for a medical procedure. This bill does not change current medical practice on late-term pregnancy termination, and to suggest otherwise is misinformed. The fact that a similar law is in place in ACT since 2002, and there is no evidence of any increase in late-term abortions. And in fact, several studies have documented that safe and legal abortions reduce the number of late-term pregnancy terminations. This just shows that we can trust women, doctors, and nurses to deal with these sensitive issues. The worst of the misinformation that is going around is the suggestion that women will now terminate pregnancies on the day of birth or an hour before birth. This is not just incredibly offensive and outrageous, but also a lie that comes straight out of the playbook of the anti-choice lobby. The reality is that only 0.7% of abortions take place after 20 weeks of gestation, and they almost always relate to severe abnormality, fetal abnormality, or serious risks to the health of the patient. The sensitive and difficult issue of late-term abortions will continue to be covered adequately, as it has been by guidelines provided by both the New South Wales Health Framework for Pregnancy Termination and RANSCOG. The scenarios that have been outlined by some are not grounded in any kind of reality or an understanding of modern medical practice. Then there is the claim that this bill will allow an abortion to be performed by unqualified people. If this legislation is enacted and abortion is legalized and easily available, are people seriously suggesting that women would bypass seeing their GP or health specialist and they would deliberately seek out someone who wasn't medically qualified to perform a surgical abortion? And a medical abortion requires medication prescribed by a doctor and dispensed by a pharmacist. This will not change when abortion is decriminalized. All these professions are regulated under the Health Practitioner Regulation National Law, and they will continue to stop unqualified people from practicing as doctors, pharmacists, or nurses. Anything done without the permission of the woman is now and would continue to be grievous bodily harm, which carries substantial penalties. To members who might claim that they are pro-choice but don't support this bill, I will say this: you cannot have it both ways. You cannot claim to be pro-choice and then vote against a bill that is exactly about choice. You cannot claim to be pro-choice and then support keeping abortion offenses inside the Crimes Act that effectively criminalize women seeking terminations and their doctors. This bill is far from radical. As Sydney lawyer Julie Hamlin put it, the changes proposed in this bill are straightforward and sensible. This bill repeals the existing offenses in the Crimes Act, leaving abortion to be regulated in the same way as any other medical procedure. The bill makes it unlawful to intimidate and harass women accessing abortion clinics. The medical privacy of patients must be respected, like we would expect from any other medical procedure. The bill allows health professionals to express their conscientious objection, and they no longer have to provide any advice related to abortion or perform the procedure, as long as they refer the patient onto either another medical practitioner or women's health clinic. This is what we are voting on today. We have come this far, and we will not stop. Today is a historic day for women's rights in New South Wales. This Parliament has had to confront an issue it has been avoiding for well over 100 years. This is only the start. We have created overwhelming momentum, and we can only move forward from here. I have been repeatedly asked why New South Wales Parliament had not ever debated the decriminalisation of abortion. Well, today we have broken that barrier. I have been asked again and again why New South Wales has not moved to give women a reproductive health choice with full legal backing when many other states have moved that way. Well, today is an opportunity for us to do this, to get rid of an archaic law and take another step forward in ensuring the rights of women in this state, like many other states in Australia have already done. As women have said for decades and reiterated outside the Parliament just this morning, not the church, not the state. Women must decide their fate. I commend the bill to the House.